Good evening, and welcome to the first episode in my series on understanding North Carolina family law for laypersons. This video is in no way designed or intended to supplement or replace the advice of a licensed attorney, and this information is limited to the state of North Carolina only. This has no bearing on any federal matters, federal appeals, federal cases. This further has no bearing on any matters in any other state, and this video in no way creates an attorney-client relationship between the presenter, which is me, and those who are out there listening. The purpose of this video is to go over just a few common misconceptions as it relates to family law, especially in North Carolina, related to child custody and child support. So without further ado, let's get started with Mr. Kohler's top 5 myths related to child custody. So tonight we're going to talk about the most common misconceptions related to child custody and child support as it pertains to North Carolina. There are a number of myths that are floating around out there, and none of them are good. In fact, many of them, a lot of them, are very, very discouraging. And frankly, there's not enough done to try to dispel those falsities. So what we're going to do tonight is we're just going to go over my top 5 worst myths as it relates to child custody. And I want to also go into this with the understanding that while a lot of this seems to be geared towards fathers, namely pro-father, this applies to all parties across the board. Because the first thing I want to point out is North Carolina is one of the very few jurisdictions which presumes joint custody in any situation where there is no court order. In other words, both parents have equal right, equal custody to the children, and each have an equal obligation to support the children. All right, so the first myth that I want to get out there is that mom has a right to custody. Mom has a right to custody. This is the first and probably the most damaging myth that's out there. Now, up until the early part of the 20th century, there was a doctrine that was called the Tender Years Doctrine. And the Tender Years Doctrine came out of post-industrial revolution, post-Civil War, early World War I, when many men were the primary breadwinners for the home. Most women did not have jobs that would go out into the workforce, and if for some reason were having a difficult time providing for the family, they would go abroad or to another state, and they would do what they could away. And then as we got into the wars, such as Civil War, Spanish-American War, and then subsequently to World War I and into World War II, it just sort of became the understanding that women would have custody of the children. So that's where that developed from. And that doctrine has been abolished in every jurisdiction, particularly North Carolina. So there is no presumption that favors a mother over a father, as far as custody is concerned. It's a matter of best interest. And I will quote Parker versus Parker, which is a very famous North Carolina case in which the Court of Appeals said that the general welfare of the minor child is the polar star by which guides the court in their determining the best interest of the child. And so what that basically means is the court has to go through a weighted factors analysis. It's basically the court's going to look at the evidence as it relates to the age of the child, age and health of the parents. They're going to look at the relationship the child has with other siblings, each parent's ability to foster a relationship with the other and to co-parent, as well as other factors such as the biggest one being stability. And by stability, how many times has the parents moved? How many times have the parents moved to a different home, and what was the reason for the move? Have they changed jobs rapidly? Have they forced the children to have to relocate schools? These are all very important issues as it relates to stability, and these are the things the court are going to consider. So when I get clients that come into my office, particularly fathers that say, mom should have custody because she's the mom, the first thing I do is I take a step back and I say, well, let's not make that decision yet. Let's look at the factors. And we go through and I ask them the questions. How often have you moved? When was the last time you moved? Where have you been? All these things going together. And then we talk about their employment. We talk about the environment that's being provided for the child, because those are the most important things the court's going to analyze. So myth number 1, mom is entitled to custody, is an absolute myth. North Carolina 50-13.2 says that upon motion of either party, the court shall consider joint custody where it's determined in the best interest of the child, which is in the process of changing, and the court is going to have to, on their own accord, consider joint custody where it's in the best interest of the child, not even upon the motion of the parties. So this is something that's coming down. The second myth is that mom can take the kids anywhere. They're my children, I can go anywhere, do anything with them. This is simply not the case. Now, in most contexts, in most reasonable contexts, this is in fact true. If mom or dad decides they're going to take the children, say, from North Carolina to Virginia, they're going to go to King's Dominion for the weekend, and they're going to have a good time. Dad transports the kids to Virginia, they go, they come back, no problem. But where we run into problems is where one parent seizes primary custody of their own. In other words, there's no court order. They just say, I've got them, and I'm going wherever I want. And this does happen, although many people don't believe me, where mom, usually it's the moms, in my experience, in the middle of the night, will simply leave with the children and go somewhere out of state. And they'll basically call dad or some other relative the next day and say, I'm never coming back because he's a narrative explicit deleted. So that situation is a different scenario altogether. And in that case, if a parent takes a child outside of the state of North Carolina for the purposes of avoiding the jurisdiction of the state, then the court at that time can intervene, particularly where it's changed the living conditions of the child, and they can enter an emergency custody order. And this is very important and something to keep in mind, especially for those folks who don't have existing custody orders and who plan on moving out of state, either to remarry or to attend school or to seek other employment. Because standing on its own, new employment out of state is not considered to be in the best interest of the child, even if it improves the economic situation for the parent. There's more that has to be analyzed. That on itself is not enough to get a court to say, yes, you can go out of state. If at any point you have a court order that gives you custody and you want to leave the state, you should then move for a modification of the custody order and get the court to say, yes, you may take them out of state. At that point, it's something that's not only a show of good faith, because the other parent has just as much right to have a say in parenting the child as you do. It's simply good etiquette. And it's an ounce of prevention. And I always say, an ounce of prevention is worth a pound of cure. So, when in doubt, go back to the court. Contact your attorney and find out what needs to be done. So that's myth number 2. Myth number 2 is, they're my kids, I can take them anywhere. Within reason, this is true. However, don't do it if your intention is not to return. If you don't have a custody order and you decide, I'm moving to Iowa for a new job herding cows, and you just decide to leave and take the children, you may be subject to an emergency custody order and an emergency return of the children. This is not something you want to be on the wrong end of. It's better to go in and get a modification. All right, so myth number 3. Myth number 3 is dad has to give up custody of the children. This, again, is simply not true. It sort of goes back to that first thing. But in many ways, in many times in my experience, fathers are very, very quick to say, I just want visitation. This is a completely wrong approach. You are just as important in creating the life that is that child that you love so much, and the reason that you're paying me so much to fight over them. Don't roll over. If the situation is sufficient to where we will, in all likelihood, prevail in a joint custody order, it behooves you to do so. You have a right to parent your child and to direct the upbringing of the child, so have an active role and take as much advantage of it as possible. We only get our children for a few precious years. Take advantage of it at every turn. With that being said, we're going to go on to myth number 4. And myth number 4 is that fathers must pay child support. This, again, is an absolute myth. Child support is based upon North Carolina Child Support Guidelines, which is an equitable share based on the obligation of each parent based upon the custodial arrangement of the children. So, basically speaking, you take the gross monthly income of each parent, it gets put into a worksheet based on the total number of days the child is with you, and then based upon a calculation, how much is going out for support of the child, how much is going out for child care and medical and everything else, it spits out a number. Generally, if you're the parent who does not have custody and you're making more, you're going to end up paying child support. Don't dodge child support. And at this point in time, I will take this opportunity to say, if at any time you have the ability to come to an agreement and enter a civil child support order versus a child support, what's called an IVD child support through child support enforcement, you are much better off. Because if you can negotiate and if you can work with the other parent in terms of support, the chances of being hauled in on a contempt and show cause for failure to provide support are much more minimal. And it's much easier to get modified. These things can be done by agreement, and you're not dealing with child support enforcement, which unfortunately, they're not always the most pleasant people to deal with. So, there again, myth number 4, fathers must pay child support. It's not always the case. There are fathers with custody whose mothers pay child support. It's just not very common. All right, final myth. This one doesn't have to do with either mom or dad. This is going out to all you grandparents out there. Grandparents, there's always this thought that grandparents somehow have a claim to custody by virtue of the fact that they're grandparents. Sorry, grandparents, this is simply not true. Grandparents have 2 ways of getting custody or visitation. Actually 3. First way is if the parents agree to grant them a visitation right in a custody order. Number 2, if the grandparents are permitted a motion to intervene and to exercise the rights of one of the parents who are, for whatever reason, not in the picture. This is usually the case where you have a parent that's a military member that's forward deployed, and the grandparents are asserting the rights of that parent while they're gone. Number 3, the Peterson presumption. Now, under the Peterson presumption, custody awarded to the natural parents is presumed to be in the child's best interest, barring a showing of unfitness of the parents. What this means is in order for a grandparent or any other third-party relative to step in and assert claim to custody or visitation over a child, there must be 1, an ongoing controversy or case between the parents, 2, there must be a showing of unfitness of one of the parents or both of the parents, and 3, a showing that that unfitness is against the best interest of the minor child and that custody should be awarded to the grandparent. That is the Peterson presumption. The Peterson presumption is that the biological parents are what's in the best interest of the child. So grandparents, those of you who think you're going to step in and say, this is my grandchild, you're not making good decisions, and I'm going to take the child, you could be in for a very rude awakening, because you can be charged with criminal kidnapping. Just be cautious. Consult an attorney. If you think that you have a situation where you may be able to assert rights as a grandparent or any other third-party relative, and we have done these cases before, you need to seek an attorney. The last thing I will leave you with, do not attempt to take a child custody action on your own. If you do not have an attorney, and you are not a licensed attorney, and even if you are a licensed attorney, I always recommend that you find a third-party attorney to step in and do this for you. Do not represent yourself. It applies to attorneys. He who represents himself has a fool for a client. Child custody and family law in North Carolina is subject to not only the North Carolina rules of civil procedure, but also other rules of procedure that must be followed. And any failure to follow those rules can result in a loss of rights. Find an attorney, pay the attorney what they're asking, be involved in your case, and I hope to never have to see you on the other side. It's always in the child's best interest where the parents come together, reach an agreement, and work together to parent the child. It is only in those most rare of circumstances where 2 parents are simply unable, for whatever reason, to communicate candidly for the best interest of their child. Thank you for listening, and I hope this was informative. You may find me on my Avvo page at Timothy Paul Kohler, attorney at law with Gunther Law Group, or you can go to guntherlaw.com, and we have offices in Virginia Beach with attorneys licensed in Virginia, and we have offices in North Carolina, in Hertford and Manteo, and it has been my pleasure to present this to you, and please take time to do more research, and if need be, please do not hesitate to contact my office if you feel you're in need of a consultation. Take care and have a wonderful night. God bless.